That is what is contained in the founding affidavit that was filed by the Deputy National Police Commissioner for Crime Detection, that's Lieutenant General Shadrack Sibiya, who says that essentially he was placed on leave of absence and told to stay home on untested allegations, and also says these allegations were made by one individual. He also says that this process and investigation must unfold, but the forum in which it must do so would be the Commission of Inquiry that's been established by President Cyril Ramaphosa to probe these allegations of rot within the police service. Now, that's what is contained in the papers for the applicant in the matter. But let's look at what is in the respondents' papers. That's Fani Masemola, the National Police Commissioner. He says that the decision to place Sibiya on leave of absence was not taken based on the 6th of July media briefing by Top Cop in KZN, Nhlanhla Qodashe, and instead is a series of events that unfolded that have led to this decision. He first places us on the 31st of December 2024 when he said that he took leave until the 13th of January 2025. He says on that very same day that he was placed, or that he took leave that would have been approved by his political head, that's then Police Minister Senzo Mchunu. Then the directive came from the minister to his office saying that there must be an immediate disbandment of the political killings task team in KZN, also saying that they require a preliminary report in that regard. Now, what Masemola then says is that he initiated, or after acceding to this request or directive by the police minister, he then said that this must happen in a phased out approach and not the immediate cessation of the work of the police killings, political killings rather, task team in KZN. But despite this, he says that Sibiya continued and even emailed particular parties saying that this must take place within 7 days. And that's the basis upon which Masemola says he then placed his second in command on leave of absence. Of course, we are in the Palace of Justice, Michelle, where you remember there's a historical context to this building, but it's also where the full bench of the Gauteng High Court in Pretoria will be hearing this urgent application. But to give us more detail in terms of the legalities of the matter, I'm joined by legal analyst Reitumetse Phiri, who's just going to speak to us and who has kindly driven all the way in traffic from Johannesburg to just speak to us about this. Now, Mr. Phiri, of course, this is an urgent application, and there is a test for urgency within the legal context. Can you just explain that to us, please?
Sure. Good morning, Zoleka. Yes, so insofar as the test for urgency is concerned, Mr. Sibiya is going to have to show that he doesn't have substantive redress in due course if the matter is not heard today. And really what he has to show is that with the operation of time, his rights will become eroded, such to the extent that they'll really be hollow in the future. And that's going to be a little bit difficult because ultimately what he complains about is to say, well, my boss has put me, said I must stay at home, and what that has done is it's institutionalized General Mkhwanazi's allegations against me, and that really is what then creates a stink around me, and the longer it goes on, then I won't be able to deal with it. But that's not really the issue at stake here today, because he'd have to show that not being in the office really affects him in a way where if he had to challenge it later on, it wouldn't give him the redress he needed. He's also got a problem because if the issue is General Mkhwanazi's allegations, he did say in his court papers that he actually will take it up as a defamation matter. Secondly, if he does get disciplined in accordance with the police regulations for discipline, he'll have that forum to ventilate that in. And thirdly, if he does actually avail of the opportunity to mention what he wants to mention at the Madlanga Commission, I think that will also, exonerate him, so to say. So it's going to be tough going for him on the urgency front.
Speaking of the Madlanga Commission, he also says in his papers that essentially this must be ventilated, or if there is to be investigations against him, they must be ventilated within the commission or before the commission, right? What challenge does this pose? Because does it mean that because there's going to be a commission of inquiry that will probe and possibly investigate his dealings or his potential involvement in the disbandment of the political killings task team, does it mean that the SAPS cannot have its own disciplinary processes?
I don't think that's what it means. And, you know, the argument that Mr. Sibiya makes is that the terms of reference of the commission essentially ensure that any type of investigation in this manner is ousted. But if you look at the terms of reference and you actually give them their practical interpretation, I don't think that's what's contemplated here. And if, you know, the issue is that Mr. Sibiya really didn't give effect to an instruction by his superior that the phasing out of the political killings task team should be phased out as opposed to being immediate, then the issue is, why would that require the Matlanga Commission to be dealt with? Because that's a direct contravention of, you know, a superior's instructions. So I don't think that argument will hold water because of what we're dealing with in this particular instance. It's a contravention of an instruction from a superior. Yes, it may collaterally spill into the other areas, but that's, you know, it's a discipline issue within the police and not a Matlanga Commission issue.
And very briefly, Ritu, the instruction to stay at home, it's unclear what this instruction is in the broader context of discipline within the SAPS, right? What will the court also have to determine in this regard?
That's a good question, because I think ultimately the matter is going to come down to whether that instruction was a suspension. I think Mr. Sibiya is really saying that, you know, as far as he understood it, he's suspended. And if you are suspended, then there's a specific process in terms of Regulation 8 that has to be followed. And that includes him being afforded an opportunity to make representations. So this instruction to stay at home did not have an opportunity to make representations, and he took it as if it's a suspension. But what the commissioner has said is well, if it was a suspension, then he wouldn't have the ability to have his work devices. You know, it would have followed a completely different practical course, and all he's being asked to hear is not attend the office, not necessarily to not have or undertake any of his duties pending a particular investigation. So I think from a court's perspective, there'll be a lot around how to interpret that, and the regulations are going to play a key role in determining whether it falls within the regulations or not.
Thanks. That was Reitumetse Phiri, who's a legal analyst, just unpacking what we can expect to take place and what the court will be seized with as a full bench of the Gauteng High Court in Pretoria. Here's the urgent application by Deputy National Police Commissioner Shadrack to return to work. It's also interesting to note, Michelle, that in Masimula's papers, he does say that the investigation into the conduct of Sibiya was concluded in August this year. So it will be interesting to hear why he has not returned to work and what the outcomes of that investigation are.